Josh, thank you so much for joining me once again. Today, I really want to focus on the entity that calls the shots on modifications. We've got a lot of newcomers, a lot of people that are new to this.
Yep.
I was hoping we could do this more directed to the lawyers versus homeowners. So give me a second here and I'll pull up the PowerPoint I came up with and we'll get going. Okay, Josh, so here's a basic breakdown of who calls the shots on a modification. And
Yep.
of course, we refer to it in our world as the investor. Obviously, investors can come in many shapes and sizes, but just as a good background, it basically breaks down into three, which would be the federally backed loans that are actually in trust. There's a couple of versions of that. And obviously anybody can own a loan. Any entity can own a loan. You buy a bunch of loans and you own it, or you own one single loan. Anything you want to add to just that? I mean, we're going to go into each one of these in more detail, but just generally off the top of your head.
No, this covers the universe. It's the interesting bit starts after we get this first page.
Okay, so federally backed. So there's a lot of loans that are federally backed. You've got Fannie Mae, you've got Freddie Mac, you've got FHA, you've got VA, you've got USDA, and you've got FHLB, which is a very little known entity out there. All of these have guidelines. The last time I printed the guidelines for Fannie Mae, it was about 6 inches thick. They go over everything. They tell you exactly what they want. They tell you what the servicer can do in great detail. And all of the other federal agencies also have very specific guidelines. Understanding these guidelines are immensely important. It really helps when you're advocating for your client. There's many mistakes that happen at the servicer level, and being able to push back on what they say or don't say, or the terms that they give on a modification, are all clearly spelled out on what they should and shouldn't do. Spend a lot of time educating via the RFIs and the NOEs that we send on a regular basis. What would you like to add to that, Josh?
Well, in my however many years I've been doing this, 20 years, I've never had a federal home loan bank mortgage case. So I don't know anything about that one. That's never seen it. Fannie and Freddie is interesting because Fannie and Freddie we're going to see on this page, and we're going to see on the next page too, because Fannie and Freddie can sell their loans into trusts and then it becomes a former Fannie Freddie. So you got to watch out for that. The FHA have pretty good guidelines for now. I think they're going to go away. The USDA, same. They're a much smaller lender, much smaller investor. You don't see them very often. At least you don't in New Jersey. You may in other parts of the country. The VA loans I want to talk about to the attorneys here is something near and dear to my heart and Bobby's heart, and it's a real issue. This is not political. I'm just telling everybody the current administration eliminated the modification guidelines in place that existed prior to the administration, and they were terminated a couple of months ago as of the July 10, 2025 date. So when I have a VA loan, previously, I want to go too details, but previously the VA guidelines were set that basically every single veteran could get a loan modified to an affordable rate, and the government would pick up a portion of the tab. That's ended. And the guidelines are so restrictive that most of these VA loans, when someone falls into trouble, are going to go into foreclosure and houses are going to be sold. So when you get a VA loan, attorneys, you need to really ask the client, did you ever apply for a loan in the past before June of 2025? Really dig into that. Because if you can get there and if the modification wasn't granted, it means the servicer made a mistake, then you have an argument to get back to the original guidelines and save this veteran's home. Otherwise, it's going to be a very difficult case. And so that's inside baseball for attorneys. Drill down. This is true. You should do it every single loan, every single investor. What happened in the past is the most important question. With the VA loans, it is crucial. Really spend the time. Really spend the time. That's what I wanted to add to the attorneys in the room.
Yeah. And the only, again, just for especially the new people, Fannie, Freddie, they both have a website. You can look it up instantaneously. It'll tell you if it's Fannie, Freddie, FHA. They have a phone number you can call. The actual mortgage and the note on FHAs, you can actually look at it and it clearly says it's FHA backed loan. VA, the same thing. You can look at the actual document and see it, and the same for USDA. And again, VA and the USDA both have phone numbers to verify. And like Josh said, A and B, Fannie, Freddie, and FHA regularly sell their loans. So even if you had a loan that was FHA when it was originated, it may not be FHA today. And we'll go into that a little bit more.
Yes, and that's why it is so important to try to see what your borrower did prior to coming to you about trying to modify. Because if a mistake was made when the loan was Fannie, Freddie, and FHA, then you got a good shot of keeping those guidelines.
So it's not just who it is now, but who it was. And again,
Yeah.
I don't want to break off from our very specific points that we're trying to make here today, but that's standard SOP. You got to get your requests for information and you want to ask these questions. Who's the owner? Who was the owner? and that doesn't necessarily line up with the assignments and all of that in the foreclosure world. So the only way you're going to know is if you ask. So here, Josh, we have pools, which is category 2 of investors.
Yeah.
And within trust, we have private trust, we've got public trust.
Yeah.
Can you just go down and talk about the differences with those?
Sure. So what we talked about on the first slide on the public entities, the federal backed entities, is the guidelines that you can get to so you know what your loan application needs to look like to get the loan modified. When you get to a trust, it's another layer of complication because it's not federally backed and there's no federally backed disclosures on a public and especially on a private trust. Putting the private trust aside for the moment, you can get information from a public trust because they have to report it on their K1s. I think that's what it is. I don't do a lot of tax stuff, but it's a publicly reported document. They don't tell you what the guidelines are, but they tell you how they've treated the loans in their portfolio in the past. And from that, you can reverse engineer, or with Bobby's help, Bobby can reverse engineer and tell you what the basic framework of the loss mitigation guidelines are. And then armed with that information, you've got their guidelines and you can tailor the modification application. And most importantly, you can identify when they do something wrong if it doesn't match what they've done in the past. That's
if you don't mind, Josh, just actual examples that we've had, right? Where they say we don't do modifications. We've had others that they say, the payment can't go up. where we get some that say the payment has to go down by a certain percentage, and simply by looking at the remittance reports, you can see that that is not actual accurate information, and then you can go into your lawyer mode.
Yeah, and the lawyer mode is taking the genius that is Bobby's analysis, turning it into a notice of error, and seasoning the file for a plaintiff suit. We've got a number of resolutions, including counsel fees and sweetheart modifications to get rid of us, where we've identified a false statement in a denial. And in other videos Bobby and I have done, we've said something what I think is pretty essential to the practice, which is a modification denial is not the end of the process. It's the start of the investigation. And that's where you build your claims. That's where you dive into either the publicly disclosed guidelines and say, wait, no, that doesn't make any sense. That's not correct. Or you find the guidelines in a privately owned entity. Now we're talking about here is public only. And I'd like to talk about the private for a moment. Do you mind, Bobby?
Oh, no, of course, please.
Okay. So the private trusts, I'm sure they have their own reporting requirements, but they're not public corporations, and so they're not publicly reported. So you can't go and get a remittance report on a private trust. You can't go and see how they've dealt with their modifications in the past. So getting their guidelines, there's only two ways to do it. Maybe three. It's basically two. One is to say to them, hey, what are your guidelines? And make your litigation about their guidelines and tell them that you think they've done it wrong. It's not the strongest argument in the world, but making their guidelines part of the litigation is sometimes helpful. When that really works is when, even though their guidelines are not public and not published, you know what they are anyway. And the way you know what they are anyway is you look at the database of modifications you've done with this private trust, and you see what's happened in the past, and you jump on a listserv and say, XYZ private trust, has anybody done a modification with them? What were the terms? You figure out what they are. Then you put together a document, which is a notice of error when they deny the client or give them a terrible modification. And you say, wait a second, you're not applying your guidelines. I know what they are. You've done 4% in the past. We've gotten 3 different modifications. You're telling me the minimum is 8. We know that's not true. So tell us your guidelines or correct it and give us a 4% loan. And we've brought federal suits based on those arguments, and we've ended up with modifications and attorney's fees. And while the argument, the legal position is not stronger with a private trust than with a public trust, it's more dangerous to a private trust than it is with a public trust. Because the public trust has information out there and they know it. The private trust has nothing out there and they know it. And they want to keep it that way. So if you can get to a place where you can make a credible argument that the private trust modification guidelines are not being followed and that the guidelines themselves are now part of the issue, you can very often, after some hardcore pushback, you can very often get to a place where they say, this guy is too annoying, I don't want to deal with him, and I don't want to give him this information. We control the situation, we can save his client's house, fine, we'll give him a couple of bucks, and we'll give the client a sweetheart mod, and we're done. That's how many of those private trust cases are resolved. A couple of them I take into federal court and they're pending, but most of them get resolved on the settlement. Do you want to talk into former Fannie Freddie?
No, actually, if you don't mind, put that together. Put all of that you just said in a couple sentences like you do.
Yeah, no problem. When you're dealing with a non-federal backed lender, you got to find the modification guidelines. And if it's a public trust, you either do the work on your own, call someone like Bobby, get the remittance report, find out what the guidelines are, and then see if your client's modification denial matches those guidelines or the modification granted matches those guidelines. If it's a private trust, you have to do a little more digging, but get and put together an argument that the guidelines are not being followed and press that. That is the live nerve. Press it. Just press it and press it and press it. The worst that can happen is the judge is going to say, I'm sorry, I'm not giving it to you. You're not entitled to it. But that means they ran the risk of you getting a different decision, and them avoiding that question and that decision is worth a lot. So that's how you deal with these private and public trusts. And the fact,
And I would just like to add that pressing is your notices of error, your motion work, incorporating those notices of error into your whether it's federal or whether it's state court action. That pressing occurs. A part of that pressing is those notices of error.
Right, and I know when we're talking about bankruptcy, we're dealing with judicial foreclosure states like New Jersey. There are a lot of bankruptcy filings, but a lot of this can be done in foreclosure court and outside bankruptcy. Inside bankruptcy, either in a state like New Jersey or in a non-judicial state where everything is done in bankruptcy, everything that we've just said applies. Everything we've just said applies. And I can tell every single bankruptcy attorney I've ever spoken to and likely ever will speak to for the rest of my career that you are leaving massive amounts of opportunity, benefit to the client, and legal fees on the table by not pushing this in bankruptcy. The denial gives you the opportunity to make them prove it. And that's where their liability lies. And that's where the client's benefit lies.
And I know we've touched on this in other presentations we've done, but again, even in your practice, Jesus, I think 30% of the deals that I've worked with you recently have been the former Fannie, the former Freddie, the former FHA, and the reperforming loans, non-performing loans that are sold. You've had a lot going on there. If you could just touch on that with a couple of minutes, I'd really appreciate it, because I think that's good, clear information for people to have.
Okay, I'm going to touch the surface. You tell me if we want to go deeper.
Right.
Okay, Fannie and Freddie are selling a lot of their loans. On this current administration, they're really, really encouraging Fannie and Freddie to sell their loans. In the past, Fannie and Freddie sold some of their loans because of high finance reasons of having to do with whatever is going on. I don't understand it. All I know is that Fannie and Freddie have sold a lot of loans and they're selling many, many more. The letters down there, RPL and NPL, relate to federal-backed loans that previously were owned by federal entities. The RPL means a reperforming loan. The NPL means a non-performing loan. So an RPL, a reperforming loan, is a loan that's been modified, and after it was modified, the federally backed entity sold it. The NPL is a non-performing loan, which means the federally backed lender sold it, sold it as a non-performing loan without a modification in place. They're sold to different places, sold in different mechanisms. The NPL are sold to private investors. That's the third section of the type of investor. They simply own the whole loans. The RPLs are sold as part of this prospectus, and there's a trust created, and then the trust, however trusts work, people buy into a trust, and then the trust is the investor, and the investors in the trust are the owner, but the trust is the one that controls. You want me to go deeper, Bobby? But
no, I do not, because we could do that. We've done it on others that we've done. I think that's a good segue. I would like to plug the NCLC like I always do. They wrote an incredible piece, an incredible article on this. It breaks it down. I think it might be 20 pages long. If you really want to understand exactly how the RPLs and NPLs work, I strongly recommend you go search on on the NCLC site or get a hold of us. We'll be happy to send a copy of it.
With one caveat, the NCLC site does an excellent job of explaining this situation, but they don't provide practical guidance. And that's something that would take an entire seminar to go through, but it's also something that you can pick up the phone when you see these things, give me a call, give another practitioner a call Bobby, and go a little deeper. That's something that fascinating area that you need a little assistance with if you haven't done it 100 times.
Okay, and then really the final group of investors is simply owners, right? A company
Yeah.
can own a loan. A company is a company can actually own the loan, the co-loan. A person can own a loan. An individual can own a loan. And obviously, if whoever that party is, they set their own rules. If I go and I buy 100 loans tomorrow, I can tell the servicer, hey, I want you to do modifications like this. And I could tell them the terms. I can tell them exactly how it works, how I want my own mods done. Okay, Josh, then obviously, finally, it's an owner, right? You have owners that own loans. And if I own $100 million worth of loans and I call XYZ servicer, I can tell XYZ servicer, these are my modification guidelines. I want you to do modifications like this. Here's the eligibility for it, and here are the terms that I'm willing to modify. Now, sometimes, like is in the case with the NPLs and the Fannie and the Freddie and the FHAs, there's a written document, right? The lawyer world, you sign something. It says, look, you're buying these loans under the condition of X, Y, and Z. That agreement will dictate. That agreement may not be publicly available. Many times you can get it within the litigation. And again, the NCLC articles really does a pretty deep dive on those contracts. But sometimes the actual seller can say, hey, when you buy these loans for the next 2 years, you can do this in the next 5 years, and it'll lay out exactly what they should be doing. And I'm repeating myself, but sometimes it tells them exactly what they should do. Anything you want to add to that?
Let me jump in and sort of recap all that for a second. The owner of a loan, as long as they're not prior agreements that they have to abide by, can do whatever they want with their property. And their property are the loans that they own. They can say you can forgive 50% of the principal if you want to get these things under current. They could say we're not doing any modifications. I don't care how much money it costs me. I just don't want to do modifications. So go foreclose or get them current. I don't care. Don't talk to me. Just send me checks. They can do that. Now, what Bobby was talking about the FHA, about the Fannie and Freddie, NPL and RPL, what he was saying is what the NPL lenders are doing, and we didn't really clarify that in the beginning, what the NPL investors, the one that bought the non-performing loans, are doing is they're saying, we do 8% modifications or nothing. That's what they say. And their servicer will say, our investor says that's what we do, and we're allowed to because we own the loan. So you can go pound sand, you can cry a river, it doesn't matter. We own the loan, we can do what we want. But circling back to that prior slide, the interesting bit is the NPL investor is under the requirements of its contract it signed with Fannie and Freddie when it bought the loan. So the NPL investor may look like a private investor, but it's private investor with an asterisk, and you have a claim to enforce the guidelines and be the intended third-party beneficiary of the contract. So that's what we're talking about here. Sorry if that's really confusing. Maybe I'll do better in person.
Okay. I think That's good. You want to wrap this up now? Thank you so much for doing this.
Oh yeah.
Hope people find it helpful.
I hope we didn't blow your brains too much because I know it's a ton of information, but instead of trying to learn it all, sort of let it kind of soak into your brain. And then when you see a case, you're like, wait, you can watch the video, you can call us, we can sort of direct you. And as you get into this and realize the power that you have, that the borrower has, is immense. It just doesn't look like it, but it truly is. And I hope you learn to enjoy this area of the practice as much as we do. I absolutely adore it.
All right, Josh. Thanks again.
Thank you, Bobby.